Good afternoon, everyone, and welcome to the Indigenous and Northern Affairs Committee of the House of Commons. We are meeting today to continue our work on S3, an act to amend the Indian Act, specifically elimination of sex-based inequities in registration. I just want to explain to our witnesses today that, as you can hear from the bells that are ringing, there will be a vote in the House of Commons in 20 minutes. This gives us enough time to hear from one of the groups, the Mohawk Council of Kananakwe, and then we'll have to recess for a moment, and committee members will go and vote. It will take about 15 minutes, and then we'll come back and hear the other two witness groups and proceed through our questions at that point. Kathy?
Call just to indicate that there is unanimous consent.
Thank you for that. Is there unanimous consent?
For continuing while the bells are on.
Yeah, okay, there is unanimous. Thank you very much for that. I will also add that we're meeting today on unceded Algonquin territory, for which we're very grateful. I'd like to welcome the Mohawk Council of Kananakwe, Joseph Tukwiro Norton, Grand Chief, and I'm going to have to ask for help with your name, I'm afraid. Could I ask you to say your name?
Chief Kasanahawe Skydeer.
Thank you very much. Welcome to you both. I'm happy to turn the floor over to you for 10 minutes. And when we get to the 9th minute, I'm going to hold up a yellow card. That means 1 minute to go. And then red card means please try to conclude. And I'm happy to have you share that 10 minutes between you any way that you would like to. Thank you very much.
Thank you.
Yawo. I don't know how we're going to squeeze 500 years into 10 minutes, but we'll give it a try. We'll give it a shot. And I'd like to begin with that this has been a long-standing issue ever since the European first arrived here in our part of the world that we call Turtle Island. And this is not something new. It didn't just start with the imposition of the Indian Act. It goes way beyond that. And meaning way beyond that is the imposition of the cultural beliefs, the language, and all the other things that have been brought here and have been enforced and imposed on us. We're still amazed that we're still here. We still speak our language. We're still able to talk about the things that our ancestors passed on to us and made sure that we did not forget, so that the coming generations would also not forget. That's what makes it a very challenging time for us, in a period in which we need to again remind some fresh faces, some new faces who've come into government about what's happened, and in particular, more specifically about Kahnawake. We consider you the younger brothers and sisters because we've been here for countless ages, and even recent research into archaeology and findings in the island of Montreal show that we go back 12,000 years ago, and we didn't come from New York State, in places like that as they claim. There was no New York State back then. In any event, we just want to make it clear about our presence here today. And this is not the first time for me. I was first elected in 1978, and I retired in 2004, come back again last year. So it's been a long time. And from that time till now, it's been the same struggle. And previous to my being on council, previous to my being born back in 1949, it was a problem back then also too. And our community has fought very selfishly for the jurisdiction, for the need to establish what we believe is our way of identifying our people and our way of allowing people to reside amongst us, the residency in our community. So it's always been a very controversial issue, and it's been a fight. One of the things I like to raise is the fact that this government is talking about nation to nation. While nations don't impose their will or their ways or their thinking on other nations. if we are to allow that to happen, then we do it of our own free will, and we have not, and we will not be persuaded to do otherwise. Although it causes us some very uncomfortable situations. We've been accused of racism. We've been accused of all kinds of various things. But because of the fact that we've had to take this stance, then that's what we have to do. We have no choice, and that's our goal, to be able to maintain the stand, if you will. And I have to be very blunt and upfront about it. No committee, no government, no provincial, federal government, no court is going to impose its will on us. And that comes not just from myself and my fellow chief here, Gus Nahawe. It comes from the community. And that's the stand that we have. That's why we're here, to provide you with this information. Not necessarily to ask you for anything to help the circumstances, but perhaps your understanding and your cooperation is what's needed. And even if you can't cooperate, then at least understand. I would like to have Gus Nahawe now take it from here and give you some insight in more specific issues.
So first I want to speak specifically about the Bill S3, and as Grand Chief mentioned, the matter of membership and registration we feel is one that's integral to governance matters for First Nations. And the fact that there's been no meaningful consultation, like we're aware there's going to be 2 phases, but the amendments are going to happen, and then there's going to be consultation after the fact, which in our opinion is a serious breach of Canada's duty to consult First Nations and to accommodate. And the proposed amendments to the Indian Act registration criteria in response to the Deschanel decision raise extreme concerns for Kahnawake, in that we have our own membership criteria, and registration of who could be a status Indian goes so far, so now it's exasperating the problems that we see in our community, as we're going to have more people coming to our community with band cards who want belonging, they want ownership of land, they want to be a part of the community, but they might never meet our criteria of who we recognize as Kanien'kehá:ka, who are Ungwehunwe, who are Mohawks of Kahnawake. So there's a clear distinction, in our opinion, of who could be Mohawk or identified as such, and what Canada's registration for status, there's a big discrepancy there. With regard to the specific legislation, we're aware that the amendments are targeting 3 main groups: siblings, cousins, and omitted minors. While the Deschanel decision drove the proposed S3 amendments that are going to happen in February for siblings and cousins, the amendments pertaining to omission of minor children extended beyond the decision that was rendered in the court. So this unilateral revision to registration criteria, again without consultation of First Nations, on this integral matter goes even deeper and as another breach of Canada's duty to consult and accommodate. The legislation lacks any provision for opting out. As the chief mentioned, we don't feel that any government or any court can decide who can be our people. That should be the sole jurisdiction of First Nations. Let's see. Again, the effects on membership is definitely going to impact our right to self-determination. The absence of some kind of provision or a mechanism is going to increase what we call the discrepancy population. Kahnawake has its own membership list. The federal government maintains a list for the Mohawks of Kahnawake, and that population is going to continue to grow after the S3 amendments, and causing, as I mentioned earlier, further problems. There's no additional monies that are going to be promised to our communities to accommodate these people. And again, as the chief mentioned early on, in terms of ethnocultural erosion, we want to ensure that we protect for our future generations what it means to be a Kanien'kehá:ka, what it means to speak our language, what it means to know how to preserve our identity as a distinct people. And when you have generations so removed that have no ties to our community, no connection to those lands, to our ancestors, but who might have had an ancestor a long time ago, but who still feel that, well, I should go and be a part of that community. You know, we're seeing as a result of the Cap Daniels decision, now there's groups that are popping up all over the country who want the benefits that go along with being a status Indian, but they don't really understand what it means to be born into nationhood, for those rights to have that citizenship. To a lot of people, it's just, well, I have a tax card now, tax exemption, free this, free education, free, but like I said, they don't have that understanding and that sense of identity that we're trying to protect and ensure. And we're fearful of the ramifications that S3 is going to have, not only on Ganawage as a community, but other First Nations who are in a revitalization process after Indian Act, after residential school. We're trying to rebuild our nations. And for Canada to unilaterally keep expanding the registration criteria of who can be a status Indian is going to further erode our identity as First Nations people, the real authentic Ungwehungwe of this land. That's all I got.
That takes, there's about a minute remaining if
They
Chief
add
Joseph,
one more thing. It's essential to understand that in an area such as land claims, as the government likes to call it, in a decision to accept an agreement between Canada and if it's the Mohawks of Ganawage, there's going to be, and there has been already, a demand that all these people, over 4,000 of them who are on the list here in Ottawa, be a part of a vote. And those people don't know anything about what's going on. All they're going to vote for is money, forget about the land. And we've seen that happen continuously right across the country. I would say keep your money, give us your land, give us back the land that we hold dear to ourselves. It's complete opposite for many of those people, because they don't know anything about and they don't care about the culture and history. As Gus Nahaw has pointed out, all they care about is the tax card, so on and so forth, and all the benefits that they can get from that.
Thank you very much, Grand Chief, and thank you, Chief, for your testimony. We will have to take a short recess, about 15 minutes now, and we'll come back to hear the other witnesses, Ms. McIver. I think, yeah, so I'll let the committee members know that the vote is at this point in 7 minutes. Okay, thank you, so we'll suspend. Okay, we'll come back from our suspension now. Thank you for your patience during the vote. We did have four panels, four organizations represented today. One has agreed to reschedule. So we have already heard from one of the three remaining, which is the Mohawk Council of Kananakwe. We're now going to hear from the Canadian Bar Association, I beg your pardon, we're now going to hear from the Union of BC Indian Chiefs, Sharon McIver, for 10 minutes, followed by Jeremy Matson appearing as an individual for 10 minutes. So, Ms. McIver, I think you saw how the cards work in the previous round. So you have 10 minutes, and when you get to 9, I'll show a yellow card so you know it's time to wrap up, and I'll show you red at 10. You've got the floor for 10 minutes. Thank you very much. Oh, I beg your pardon.
We do know that the bells are going at 5:15. I'm just wondering if we're lucky to be in center block today, if we can have an agreement now to go straight through to 5:30 so that we can plan
Is
accordingly.
there unanimous agreement to that? Yeah, very good. So we'll carry on right through till 5:30. Thank you for that, Kathy. Sharon, Ms. McIver, the floor is yours. Thank you.
Thank you. My name is Sharon McIver. I'm appearing at this committee for the Union of BC Indian Chiefs, who is a BC group of chiefs that have been in existence since the mid-1970s, whose major focus is Aboriginal title right and treaty rights. Today I'm just speaking specifically to S3, the amendment to the Indian Act. And you have to understand that status under the Indian Act is exclusively the jurisdiction of the federal government, and it's 9124, and so it's a relationship or recognition about who the federal government recognize as Indians. And it has nothing to do about self-determination, has nothing to do about self-government. Those issues are out there to be discussed at another time, another place. In up until 1985, the Indian Act was blatantly discriminatory against women. Lots of pressure were brought, but mainly the Charter of Rights and Freedoms kicked in on April the 17th, 1985, forced the government to deal with that ongoing discrimination. Bill C-31. There was an agreement at that time between Minister Crombie and his department that although he wanted all the discrimination gone, I understand it was too expensive, so he allowed the second generation cutoff, said those guys can come and fight for themselves. And I took up the challenge. And in July of 1989, I started a case that was called the McIver case about the ongoing discrimination in the Indian Act. And in 2010, after court decisions, the government got together to do Bill C-3. Bill C-3 continued with the discrimination. We've been here before, done this before because of the ongoing discrimination, and the government decided it was okay to continue to discriminate against Aboriginal women and their descendants. Looking at Bill S-3, exactly the same thing. And I can tell you what happened in 1985. The government threw out this thing to say, oh, we've got to consult with the people about whether or not we should end this discrimination. And from my perspective, in most human rights, people who believe in human rights, discrimination isn't negotiable. Discrimination, as the Government of Canada, it's your responsibility to make sure that your legislation complies with the Charter. So you can't go out and ask all of those Aboriginal organizations, mainly led by males, is it okay to continue to discriminate against the Indian women? And I can tell you that most of them will say yes. We know because in Jeanette Corbière-Lavalle's case, Assembly of First Nation and their allies were sitting against her with the government. Other cases that we've taken, those male-dominated organizations sit on the other side. So it's your fiduciary responsibility to make sure that your legislation, no matter what you pass, complies with the Charter. Bill S-3 does not. What Bill S-3 does, it continues the discrimination, and I have a petition with the Human Rights UN Human Rights Committee to say that C3, the McIver amendments, did not take all of the discrimination out of the Indian Act. That's sitting there. It was to be heard in July of 2016. The Department of Justice put in a request to the UN committee to suspend the hearing of my petition because the bill, now S3, that will bring gender equality to the Indian Act in February the 3rd, 2017. I do have, I handed a petition to, or a package to the clerk. There's a release, a media release that Carolyn Bennett promises that. I've also in the package got the petition, the request to the UN committee by the Government of Canada, and in several places they said that by February the 3rd, 2017, all known discrimination will be out of the Indian Act. They knew it, and they could do it. And then they were going to do a second phase, consulted with the nation to nation with the Aboriginal people. And the only thing that I'm saying today, yes, consultation. You cannot consult about ending discrimination. You cannot consult about asking somebody else's permission if it's okay to continue to discriminate against me. It's totally unacceptable, and the position that you're taking as parliamentarians is really untenable. I just absolutely can't understand why you're doing it. Discrimination is contrary to the Charter, and you know, and I know, and you've heard probably from a lot of people that there's still discrimination in the Indian Act. You have the ability to scrap the bill and do something that's going to take all of the discrimination out. And in 1985, the Government of Canada did something that helped take care of some of the bands' problems. The bands are not nations. The bands are an artificial construct by the Government of Canada. But what they did is they separated the membership and status. Section 10 allows absolutely every band in Canada to decide who can be a member, as long as they cannot take membership away, and the women who married out were to be put back into their birth bands, but second generation can be left out. You don't have to give membership to them. So they separated that out, so that the Government of Canada is determining who is an Indian and who do I have responsibility for and who do I have a relationship. They have absolutely every band in Canada has the right to make a law that determines who their membership is. And so I just don't want the water to be muddied there. What we're looking at is Government of Canada deciding whether they're going to recognize me as an Indian. And I guess the other piece that's really, really important is that when I was born, I had birthrights. Outside of the human rights that every human is born with, I have Aboriginal rights that come from my heritage. And those cannot be defined away. I cannot be discriminated against, so I cannot exercise those rights. And recognition of me as an Aboriginal person is one of those rights. And so when we're looking at what you're doing with Bill S3, what you did with Bill C3, what you did with Bill C31, you violated my rights as an Aboriginal person. And my plea to you is you can clean it up. If you look at in May of 2010, the committee, House of Commons committee, reviewing Bill C3, brought to the House an amendment to Bill C3 that for the most part, alleviated all of the concerns about the ongoing discrimination based on gender. And that was rejected. Well, actually, it wasn't rejected. The Speaker ruled most of it out of order and left in one piece. But you know how to do it. It's there. I put that in the package as well. It's a two-pager, and it will alleviate most of the discrimination. All of the known discrimination. There are some things still there that need to be fixed, but for the most part, it's doable, and that's your fiduciary responsibility. You cannot continue to make legislation that has known discrimination in it. It's your fiduciary responsibility to take it all out. That's what the Charter's all about. Thank you.
Thank you very much, Ms. McIver. We'll move right into the testimony from Jeremy Matson, who's appearing as an individual. And Jeremy, you've got the floor for 10 minutes.
Hello, my name is Jeremy Matson, and I would like to thank the Algonquin people for allowing me to speak on their traditional territory. I'd also like to thank Mr. Deschanel, Ms. Yantha, Ms. Sharon McIver, her son Jacob, Ms. Sandra Lovelace Nicholas, Ms. Bedard, Ms. Lavelle, Mary Tuax Early, and many others who continue to advance or have advanced Indigenous people's rights here in Canada. Currently, I'm registered under Section 6.2 of the Indian Act under Bill C-3, the McIver Bill, which is the Gender Equity in the Administration Act. I'm a Squamish Nation member, and I have direct ancestral connections to the Tsleil-Waututh, Musqueam, and other Coast Salish nations. And I am married to my wife, Taryn Matson, nee Moore. We have 2 children, Iris Matson, who is 8 years old, and August Matson, who is 5 years old. I am a grandson, one of many grandsons of Nora Johnson and Vino Matson. My grandparents were married in 1927, and due to my grandmother's marriage to my non-Aboriginal grandfather, my grandmother was commuted under the 1927 Indian Act and remained disentitled to her identity. My father, Eugene Matson, was one of 7 children born to my grandmother Nora and Vino between the years 1928 and 1942. And my grandparents had approximately 30 grandchildren. We'll go into the effects of the upcoming S3 about those 30 grandchildren. My grandmother remained disentitled as a band member or as a status Indian until, or a recognized Indian under the Indian Act until April 17th, 1985. And under Bill C-31, the amendments back then, my grandmother was registered under Section 61C of the Indian Act and as registered as a band member under Section 11 of the Indian Act under the Squamish Nation. My grandmother's 7 children were registered for the first time under Section 6.2 of the Indian Act, Bill C-31. So Canada has imposed discriminatory legislation against my family for 90 years. The intergenerational impact is significant. Canada has denied our cultural identities and or placed my family members in an inferior position compared to other Indigenous families in Canada. And the sole reason is because of gender discrimination and its adverse impact. So Bill S3, the nuts and bolts of the S3 as drafted and its shortcomings, I'll go a little bit into that, how it affects my family. And so I will be potentially entitled to Section 61C(2) under the proposed amendments. And I'm going to go through my children. That means they'll be entitled to Section 6.2 Indian status under this bill. But there's a few inequalities with your tinkering of the Indian Act. You've created more problems, or not you, the committee, the INAN committee, but the draftees. So I'll go through C(4), and this is part of the S3 draft amendments, and how my children meet some of these categories, but will be left out from Section 61C4 Indian status. So if we go under the first category, it says one parent is entitled to be registered under paragraph C 2, that will be me. My children meet that criteria. Then under clause 2 of C.4, the other parent is not entitled to be registered. That would be my wife. And then under 3, the category 3, it states they were born before April 17th, 1985, whether the parents were married to each other at any other time of their birth, or, and this is where my children, or they were born after April 16th, 1985. My children meet that. And it says their parents were married to each other at any time before April 17th, 1985. So my children do not meet that category, so they're not entitled to that subsection of section 6.1 C.4. So the newly entitled under Bill S3, so that means the generation below mine and descending generations from there, the newly entitled great-grandchildren or their second generation cousins of my grandmother, the descendants of my grandmother, and will be treated in a differential manner. Some will be entitled to Section 6.2 Indian status, some 6.1 Indian status under the proposed Indian Act amendments under S3. In my submissions, I broke down various, all 30 grandchildren and how their standings will fall under S3. The first 3 grandchildren before that were born to my grandmother, they will not be entitled under this bill. They were not entitled under C3 because they were born prior to September 4th, 1951. And they'll remain disentitled to Section 6.1 or Section 6 Indian status and their descendants too. I also broke down in my submission and highlighted in red. I don't know what version you got of the submissions I provided, but the first generation cousins or the grandchildren, they're highlighted in red. Those will be the individuals who were married prior to April 17th, 1985. They will be entitled to pass 6.1 Indian status to their children. And then the remaining non-highlighted grandchildren, which I fall under, I will only be able to pass 6.2 Indian status to my children. So there's going to be differential treatment between siblings of families in my family. First generation cousins are going to be left out or left with an inferior status. And on page 6, I broke down a detailed chart for the INAN committee, how I will be treated differently, my family, my children, in comparison to my first generation cousins' family and their breakdown. I would encourage this committee to look at that as it could be a possible recommendation. If you're staying in all the 4 corners of Bill S3 and what Justice Mass had done with her decision in the Deschanel case, I submit my submissions and recommendations would stay within those 4 corners, but it would be nice to have everybody under Section 6.1A Indian status who were born prior to April 17th, 1985, as Ms. McIver had mentioned. So, not too long ago, only on October 25th, Canada had gone under its review with the Committee on the Elimination of Discrimination Against Women. Canada is a part of that, is a treaty member of that particular United Nations committee. And that was in the 65th session on Canada's review. And on November 18th, only a couple weeks ago, this CEDAW committee from the United Nations with the report CEDAW/CCAN/CO-89 had called Canada out about this very Bill S3. I provided that in there, but I didn't provide the reference and the web link. I forgot to put that in my submission, but the committee in its paragraph 12 and 13 asked Canada and stated, it further notes that the new Bill S3 amending the Indian Act is currently being developed. However, the committee remains concerned about continued discrimination against Indigenous women, in particular regarding the transmission of Indian status, preventing them and their descendants from enjoying all the benefits related to such status. And they go into paragraph 13, recommending to the parliamentarians and to fix that. So the CDAW committees have, this is the third report that it's announced to Canada to abolish or fix this discrimination. And I currently have a petition before this CDAW committee about Section 6 of the Indian Act and my relationship between the state and me as an individual, my children, and future descendants, my grandchildren. So, and I also listed numerous other United Nations reports calling Canada to abolish this and provide you the links for that. And, well, the way it sits right now, the recommendations, I'll get these out, for Bill S3, it would be nice for this committee to provide recommendations 6.1a, Indian status for everybody born prior to April 17th, 1985, and also to provide future amendments because from April 17th, 1985 to the present day, there's implications there too. So it's not just April 17th, 1985 and back to 1876 or before that about the discrimination. We also have to go forward after that date too. But for staying in the four corners of this bill, to provide Section 6.1c4 Indian status to all the newly entitled, meaning my children's generational level, and not to create differences between first-generation cousins or siblings, and also to provide, recommendation number 2 is to provide Indian status or entitlement for all those individuals born prior to September 4th, 1951. And as my family history clearly displays, I have 3 first-generation cousins who remain disentitled under S3, even though the CDAW committee has recommended to Canada to fix all discrimination.
Thank you very much, Mr. Matson. In fact, thank you to all of the witnesses this afternoon. We're going to move right into questions from committee members, and we're going to go through a round of 7-minute questions, and that 7 minutes will include the time allotted for the question as well as the answer. So 7 minutes total for the question and answer. And I'll use the cards the same as I have been already, 1 minute remaining. The first question of 7 minutes comes from Gary Anandasangri, please.
Thank you very much to all of you for being here today on the traditional lands of the Algonquin people. And we, on behalf of the committee, I know it's, we've already mentioned, we do apologize for the interruption and the delay in starting the proceedings. I'd like to really, from what Ms. McIver is saying and what the chiefs are saying, there appears to be two major issues here. One is admission into the particular communities, and one is that of entitlement under the Indian Act in order to be registered. And I'm wondering if you could both comment, or all three of you can comment on how we reconcile that. And I know, recognizing that nation to nation does have specific meaning. If you can give us some guidance as to how we can reconcile it, and all of you had very compelling arguments in your favor, but we would like to get a sense as if it is possible to reconcile these two trajectories.
Not sure if I understand your question.
So, from my understanding, what you're suggesting is that you're unable to register. You don't believe that you're able to register those people who will be extended registration under S3, because as a nation you have decided, and your people have decided, that the issue of citizenship is one that is you're privy to only. And what Ms. McIver is suggesting, and quite rightly also, is that discrimination is discrimination, and it cannot continue. So, and then I'm not suggesting that this is contradictory, but how do we reconcile what appears to be two contradictions in some respect?
I'll start, and I'll ask Gus Nahui to finish off. There is, I guess, no reconciliation, if you will. we've approached this matter, meaning Ganawage, in 1981. It was the first time we passed a resolution at our table, and we sent that to Ottawa, not for their approval, but for their information, saying to them that this is what Ganawage has decided to do, that the provisions of the Indian Act will no longer apply to our community, and that these regulations now that we have developed will be the standard. And whatever you do in Ottawa has to meet that standard. It's not the other way around. That fired the signal, that began the process, and Ottawa did respond by saying that, you know, if you do that, then you're enfranchising all of your people. You're getting out of the Indian Act, more or less. That was their response. And we said, no, we're just taking over what we feel we need to take over.
I don't think Canada can make Mohawks. And how it gets reconciled is beyond me. We've tried to come up with ideas of put them on a general list. If they can go and pass through our criteria, then we'll welcome them into the community. But if not, well, then you made them Indians. You gave, as Sharon had mentioned about the relationship between Canada and the band, you have created Indians. But in our opinion, you cannot make Mohawks of Ganawage. So when he said we took that first move in 1981 to rectify the discrimination in the Indian Act against Indigenous women. Our women who married non-Indigenous men lost their rights. So we said, okay, well, in order to rectify that, any non-Native man who marries, any Mohawk man who marries a non-Native woman will also lose his rights and will have to leave the community. That was the only thing we had at that point. And then, yes, 85 came in and tried to mitigate and rectify those issues, but the problems had already been created. And every single amendment that you guys make that tries to rectify, I understand what she's saying. You can't consult on discrimination, but you can consult on how your decisions unilaterally impact on our communities. You know, because like I said, for us, we have criteria of how you could be recognized. We didn't do a Section 10 because for us, we have very strong principles. We talked about early on about provisions in the INAN. We're not voters. We don't like to vote. You know, we talk about 2% of the Canadian population can change the whole government, but we have to have a double majority to do a vote, to have any kind of decision in our community. Where's the logic in that? So how do you expect us to do some kind of a takeover of a Section 10 when our community is adamantly and principally against voting? It doesn't work for us. So Canada taking the one-size-fits-all approach, again, to rectify registration is our argument in saying that you're not considering the communities who have just self-asserted our own rules, and that, you know, to us, identity and belonging is paramount to our existence as a people, and Canada continuing to meddle in that is not your business. You have gone so far now, I think, in your authorities. You know, maybe the thinking of some of the other First Nations across Canada is they look at Canada as the Almighty Father that has all the answers, but we say we were here long before you, and the answers lie in our communities, and that's where these decisions should rest.
Thank you.
I don't have a lot more to add. It was really clear that Section 10, part of the Indian Act, was put into place to help alleviate these kinds of difficulties. I know across the country of at least 37 bands that have their own membership codes, and those membership codes continue to discriminate against the women and their descendants. Canada allowed that to happen, and we're not talking about Section 10 here. We're talking only about status. We're not talking about membership. You're not addressing membership in S3. And so what we're looking at is there is the ability to determine that you could not refuse to take back the women who married out, but you do have the right to not include anyone beyond her. okay? And then there are several bands that did not take the women back at all. And those membership codes are still in place, challenged but still in place. And so we're talking apples and oranges here. We're only
Ms.
talking
McIver,
about the relationship
I'm sorry to interrupt.
between the government and the mainly Indian women and their descendants.
We'll have to leave it there, and I'm sure there'll be an opportunity to get more of that response out in next questions. The next question is from Arnold Veerson, please.
Thank you, Mr. Chair. On last week, Monday, on November 21st, we heard from the litigants in the Deschanel versus Canada case. They were one of our first witnesses on this bill S3. Mr. Deschanel and his chief were here, and they told us that they hadn't been consulted at all on the drafting of this bill, even though they were more than willing to work with the department. They in fact told us that the first that they had learned about the bill was when we called them to come and testify before this committee. I note that the minister has since apologized to them, saying that they should work together to draft a new bill. I was just wondering if you have any comments about the engagement on this bill. Were you engaged at all prior to this? And do you think that not engaging with the litigants in the case was adequate as well? So just open it up, starting on this end and work our way across.
I find it very surprising that the chief, Rick Obomsawim, we're familiar with him, didn't know about it, because I even questioned him when they came to present in Montreal with regard to the S3 amendments that was going to be coming. And I asked him point blank, I said, Chief, did you consider how, pushing forward this legislation all the way to the Supreme Court was going to impact First Nations across Canada? And he looked at me and he says, I knew you were going to put me on the spot. And I said, well, what's your thoughts? And he goes, well, sometimes what your own principles and thinking are might not be the same as what the community is. And I looked at him puzzled, and it got me thinking, it's funny that Ganawage gets called the counting Indians, because we tend to count blood quantum and how much native you are. And the reason for that is, I think, historically our people depended on going to work in the United States. And the United States does have criteria about who could live and work in the United States. The Jay Treaty, there was a requirement to be 50% blood quantum. So for us, it was very important to maintain that. And I think that persevered over time into our laws. So when you look at a community like Odanak, there's no criteria of who could be identified in that community as being Ojibwe or what are the communities? Anyways, Abenaki, sorry.
I get more. The question is, were you aware that that S3 was being drafted?
Of course, we were aware. We were aware once the decision happened, and we looked at it and we says, oh my God. When you look at blood quantum, we were very worried about how far the amendments were going to go to identify people as being status Indian under the Indian Act. We know what 85 did, and I agree. The women should have been welcomed back. We welcomed them back in our community. And then the children of the children after McIver. So now Deschanel goes further. And at what point is it going to stop? If you remove the 6-2 cutoff, you might as well make non-Indigenous person Indians. That's how we look at it.
Okay, thank you. Ms. McIver?
Well, you did make non-Indigenous people Indians, and in 1985, when we lobbied to have every non-Indigenous woman who had married in and received Indian status to have that status removed, the parliamentarians said no, we couldn't do that. They basically said they lowered themselves enough to marry an Indian, therefore they deserve to keep their status. So we did not get notified. We found out after the fact on a website that this bill had been drafted, and it had been there was on the department's website it was there. And but with McIver, we got a completed. We did not get notified. We did not get consulted. What happened is that they started setting up the committee, and we were invited to come and talk, the same as Deschenaux. Right. So no, we didn't get consulted, and when we did get consulted, it was right here at this table, okay. And we successfully convinced your counterparts in 2010 to change the law, okay. And they attempted to do that.
Mr. Masson.
I personally wasn't consulted. I approached the INAN committee and the APA committee, and that's how I was able to submit something to the APA committee and also the INAN committee. But just to answer another question, back in 2010, the Assembly of First Nations, from July 20th to the 22nd of 2010 in Winnipeg at their General Assembly, and this was passed by consensus. It says, therefore it be resolved that the Chiefs and Assembly support the efforts to remove all discrimination against our people, including gender-based discrimination, from the Indian Act registration provisions. So the Assembly of First Nations have written me letters about various legal complaints, human rights complaints, the Congress of Aboriginal Peoples, the Native Women's Association, so all the three main national organizations, and a lot of the regional organizations too across Canada have supported me and my United Nations petition. So the support's there to remove the gender discrimination, and I have documents that go to answer your question. I don't want to be left out with that because it's important that the AFN had.
Thank you. One last question. This is perhaps the first piece of legislation that the government is bringing out on the Indigenous file. Do you think that this is the way that this has been handled, is this consistent with the Prime Minister's pledge and all the mandate letters to build a new nation-to-nation relationship? Could I just get you on the record, each of you on the record for that?
When the Conservative government was still in office, they had actually when the Supreme Court ruling came down, they had put made an appeal, they made an appeal, and then when the Liberals got in, they withdrew the appeal. So that, to us, at the forefront, they should have consulted whether we thought that was a good move. And just to go back on your last question.
Just briefly, if you could, we're actually out of time on this one.
We were never fully consulted, but we found out about it after the fact. Okay, just wanted to make that clear. Thanks.
Thank you for that. The next question is from Romeo Saganash, please.
In fact, that was a good question, so I would give some time for the others to answer the question.
In any order you would like, Chief Norton, if you'd like to respond.
No, it's just Joe and I are looking at each other. Both of our mics are on.
Whoever wants to start.
Ladies first.
All right. Okay. I don't think the government knows what nation to nation is. I don't think they know how to consult. And I definitely am convinced that they, whatever they're doing, it's not nation to nation. Because if they were going to consult nation to nation, they wouldn't be consulting individual bands. They would not be taking great leadership from the Assembly of First Nations, who is there because they're the chiefs of made-up bands. Our nation, which is very small, we have 8 bands in our tiny little nation, and each chief is talked to individually. If you go to the Assembly of First Nations meetings, BC holds sway because we've got about 1/3 of the bands in our province. And of course, we're very small. Our population is very small, but we got 1/3 of the bands. It's a made-up group. And so we're not talking nation to nation. You can't talk nation to nation unless you've got a nation. And we as individual bands are not nations.
On the other hand, in the East, there are unceded territories. There are no, or there are very few numbered treaty territories. What we go by is ancient relationships, such as the Turo Wampum. Without going into a long explanation of that, two nations side by side traveling the river of life, joined by a chain that they polish, talk to each other. They don't impose on each other. You stay in your tall ship, as we described it. We stay in our canoe. Your religion, your culture, all your people are in that tall ship. We're all what we have is in ours. And if we decide to cross over in each other's, we do it by agreement. We don't force it upon each other. That's what we believe in. That's what was given to us 450 years ago, when there was no such thing as a Canada, the United States, when there was the Dutch, the British, the Spanish, the French, whoever came here. That's what we believe in. And that's what we have in our minds, in our hearts to this day. That's nation to nation.
Mr. Matson?
Sorry, I was listening, and can you quickly repeat your question?
I think the question, you want to repeat it?
Yeah, my question was just, do you think that the way that the government has handled S3 is consistent with the mandate letters that they said to build a nation-to-nation relationship?
As an individual, I wasn't apprised to any information about the nation-to-nation. I do belong to a nation, and I have a relationship with my nation, just like I have a relationship with the Crown and Section 6 of the Indian Act. I have my own relationship with my own nation, and every family within the Squamish Nation is affected by Bill C-31, Bill C-3, and now the S-3. So it's important to a community such as mine.
Thank you. I have about 3 minutes left. Thank you. First of all, welcome to this committee, and I've listened very carefully to your presentations. I wholeheartedly agree to everything you said, each and every one of you. I too had similar feelings when I was asked to sit on this committee finally and become critic for Aboriginal Affairs, with this coming in as a first task. How do you improve basically archaic, colonial, paternalistic, discriminatory, fundamentally racist legislation? I have a very difficult time with that. And I listened very closely to you, Joe, about what you talked about when you talked about imposition of legislation, jurisdiction, nation to nation as well. And it reminded me about the 2004 case, Haida Nation versus British Columbia, where the Supreme Court talked about reconciliation. And the Supreme Court in that case said the objective is to reconcile the pre-existing sovereignty of Indigenous peoples with the assumed sovereignty of the Crown. And I think you hit it right on point when you talked, when you made your presentation. On that, I'd like to ask you, how do you deal with the situation surrounding your way of doing things with respect to membership? I know that the Canadian Human Rights Commission has supposedly stepped in. I don't know if it's the case. How do you deal with that?
Well, to begin with, I would like to just jump back in time a little bit to a date, 1990, which is infamous, and people here who were born before that date will remember what happened with the Mohawk Nation, Kanesatake, Kanawake, and to some degree Akwesasne. Without going into a great deal of detail, what happened back then was a situation that arose that created this whole rethinking about the relationship between Canada and the Native people. It wasn't just Mohawk people. It's right across the country because everybody jumped in, became involved in that. Fast forward that to today and what we're living with. The aftermath simply has given us and has given rise to this pride and this demand that we must do things the way our ancestors provide us the methods to do these things, and in a modern context, if you will. And that's what this is about. And there's much more to it than that. I know you ask a very, very complicated question in a way, but in a very simplistic way, we are allies to Canada. We are not subjects of Canada. Therefore, this applies, and not the Indian Act. Although that's what's applied, that's what's been placed upon us for 150 some odd years.
Thank you for that. The next question is coming from Don Rusnak, please.
Well, thank you for appearing before this committee today. I tend to agree with a lot of what was said here today, but where I struggle is this is a very large country, and we're dealing with this one issue as a pan-Aboriginal issue because of the Indian Act, and the Indian Act was designed to control Indigenous people across this country. We all know that. It's done a very good job at destroying communities, destroyed my community. I'm the only First Nation member of Parliament from Ontario. Sitting here listening to witnesses testify either way about this piece of legislation and other things we've heard here, the one thing that's clear to me is certain communities are at different levels in terms of governing and in terms of capacity to control their own destiny. There's still communities, and this is my worry, and this is why I see the need for this change to the Indian Act, is there's those communities that are so dependent upon the Indian Act that these changes will hopefully we'll get the numbers from the department and where these people are coming from, help these people so they don't slip through the cracks. They're at the very bottom of this country, and they need that support that comes from the Indian Act because they don't have anything else. And that's the reason I see the need for these changes, so we bring them in and they have those benefits and protections. But that's not what I see going forward. I see our communities, and myself and member Gary Andesangri were the Mississaugas, where they signed an accord to cooperate and negotiate with the government as a nation. And that's where we need to be going, and having an agreement over land resources and how that relationship's going to look is where First Nation and other Indigenous communities across this country, in my view, need to go. But right now we're discussing S3, and of course your community is in a different position, and it's great to hear that perspective at this committee. But what would you suggest we do as the government in respect to this legislation, understanding that it's not just going to affect your community, but it's going to affect all those other communities? And I'm not saying that's right. We have to get away from the pan-Aboriginal approach to dealing with communities, because the Mohawks are very different than the Cree in northwestern Ontario, or different than the Tsleil-Waututh in Vancouver. And the way I explain that is that if in Europe, people in northern Poland are not going to enjoy and like the same things and don't have the same culture and language as people in southern Spain, although they're all Europeans. So we need to do things differently, and dealing with it under one department and dealing with our Indigenous people across this country as a homogenous society or cultural group is wrong. But what would you suggest, given the situation we're in, we do with this piece of legislation?
If I may, the European Union is starting to show some cracks, as you know, although we're not in Europe. But we've been approached, and we've talked to the minister, we've talked to the deputy minister, and they've talked to us about how to extract us from the Indian Act, more or less. How do you get out of the Indian Act? Well, we can negotiate or find solutions to just about everything that the Indian Act engulfs us with. But there's two areas, land and membership, that we're going to battle like hell over for. And we're doing that right now. So, as my colleague mentioned earlier on, that, you know, this is not a one-size-fits-all approach. And, you know, in various parts of the country, we understand that people need to have the Indian Act. They need to work with that. So changes that can be made to suit them are not going to suit us. And we don't want to fight with anybody. I don't want to fight with her. I don't want to fight with him over that. If it fits what they need, then fine, let it fit. You know, so you're going to have to go, I think, very carefully, case by case, look right across the country in terms of what can happen, what can be done. We're ready. We're bursting at the seams in terms of the Indian Act and its application, and especially in this one situation. Understand there's a Charter of Rights. Understand there's discrimination, you know, the appearance of discrimination, and something has to be done. But there has to be a way that Canada has to look at it and say, well, that's Kahnawake, that's the way they do things. It's not going to change.
Ms. McIver?
I'm very, very clear on this piece of legislation. Needs to be fixed. You need to take out all the discrimination. It's as simple as that. It's not rocket science here at all. And just to follow up on what Joe said, I was part of a constitutional consultation committee in 1989, 1990, and we went to his community to consult, and they invited us into the big house to consult. And what they said, what one of the matriarchs said, because they were talking about the Charter of Rights and Freedoms and the discrimination, and their system is led by women and matriarchs. And they said, well, what would happen if one of the men wanted to be a matriarch? And they said, well, we'd put a dress on him, and he could do what he wanted to do within our system. He said, she said, but there are women out there that are discriminated against. And we, as the Mohawk people, have been around for centuries, and we can take care of ourselves. So, and that was given, I was on the panel in, I think, 1989. And it's exactly what you said.
Thank you, Ms. McIver. We'll have to leave it there. Thank you very much for that. We're moving into 5-minute questions now. And the first question is from David Yurtiga, please.
Well, thank you, Chair, and I'd like to welcome our witnesses here today. Your testimony is instrumental on us moving forward on S3. But it seems to me that, you know, the S3 consultations were very limited. Some were consulted and some were not, which poses a problem. If we want to get a real perspective of what First Nations need and how they want to proceed, it seems to me that that should be coming from First Nations, not from us. So if we had to change S3 to make it work, what changes are necessary so it'll be all inclusive and to, you know, to get rid of some of the issues that we're hearing today? So what changes would you like to see in S3? And I guess we'll start off, whoever wants to answer it, or I can hear from each individual people, the witnesses.
Well, I'll start. take the discrimination out. And up until 1985, there are, from the time the legislation was put in place, whatever version it was, up until 1985, there was discrimination against women and their descendants. That's all that I am asking. Take away the discrimination and put the people where they should have been had the discrimination not taken place. And as I said, they attempted to do it in 2010. There is the copy of the report to Parliament then, and it's fairly simple to do. To make sure that anybody born before April the 17th, 1985, whether they were descendant from a male or a female, are treated exactly the same. And that means in their registration, we don't want 61C101 and 61C104. You know, there are categories there that are just making everybody different. And just because a woman married out and her descendants didn't have the advantage of being into their community and learning in their community doesn't mean that they are not entitled to belong to that group. And so just take the discrimination out. I can say it's not hard.
Any other comments?
I just think Canada is in a conundrum one way or another because you're not going to please everybody. And, you know, I know she's saying this is all you have to do and that's it. But at the same time, you know, the impacts that it's going to have on the First Nations across Canada is Mr. Runsnack had mentioned, you know, some of them depend on these amendments and think it's going to be the greatest thing, you know, because it's going to further their numbers and ensure that, you know, their continued existence as a band is going to continue. And for others, we look at it as, oh my God, there's going to be all these people that are added to our community who don't know where Ganawage is or what it means to be Ganyagahaga. So, you know, you're going to have, you know, an issue one way or another moving forward. And I had proposed at one point maybe registration and who could be a status Indian. You need to have general lists instead of giving band cards and tying it to specific nations or tying it to specific bands, or even make Ottawa a designated reserve if you have to and tie them to being Indians of Canada. Ottawa Indians. Because I know it's funny, but I mean in terms of where the connection to being tied to a community, you know, if they don't meet a specific community's criteria, if they did a Section 10, or if not, well then they got to go somewhere. They got to be tied to somewhere.
The Algonquin Nation may have something to say about that.
Yeah, it's true.
We do have a band in BC that took anybody. They saw themselves on a sunset band, and they took anybody. They've advertised, say, if you want a band, you can transfer to us. We will take you. And there are bands, according to Stuart Clatworthy, by 2030, they will no longer exist because of the sunset clause that's now in the Indian Act.
Thank you.
Thank you. We'll have to leave that question there. We're out of time on that one. The next question is from Joël Lightbound, please.
Bonjour à tous. Je vais parler en français, donc.
Hello, everyone. I'm going to speak in French, so you might want to put your earpieces on. Bill S3 that the government has put forward, I've understood your reticence on the parts of each of you. It remains a bill that responds to the Superior Court decision. I know it's not the final product, it's one step. I'd like to know what you think about what phase 2 that the government has proposed in the process of consultation. What should it include, And what results would you like to see from phase two to which the minister has committed? Might start with Mr. Madsen.
Consultation for phase two. What should happen? Well, I've looked at the government's website about phase two and the proposed dialogue that you've already set up. I would look at all the case law that's before the courts, before the United Nations Inter-American Commission on Human Rights. Look at all the issues that are out there. Ask individuals, not just nations. Ask non-Aboriginal organizations who specialize in human rights, and talk to the Canadian Human Rights Commission about their perspective on things, and of course consultation with the nations, and every band or nation should be consulted, because they'll be affected by those proposed proposed dialogue in phase two. And I have some suggestions, because I have other family background, not about this discrimination, but other discrimination that affect my family members too, that stem from Section 6. So another subject, another time.
Madame McIver.
I'm really unclear about what they want to consult about. Perhaps membership. I don't know. I know that they don't have the right to consult about discrimination. That no one has the right to say, okay, it's okay to discriminate. They did it for C31. They did it for C3, and it looks like that's their intention for doing it for S3. Whoever they consulted is saying, okay, it's okay to discriminate. We don't want any more. There are some that want more members as well, but the consultation is never, ever, ever been sufficient. I cannot think of any consultation in the last 50 years that has resulted in anything. You go and talk, and you do what you want to do anyway. And so my concern, my immediate concern with S3 is that it seems, instead of taking out all the known discrimination in the Indian Act, the minister has now decided, well, we won't take it all out, even though we know it's there, and we'll consult with people about how we're going to do it. Doesn't make any sense to me. So I'm not a big fan of consultation in this kind of legislation. Yes, when you're looking at land, if you're looking at resources, if you're looking at all those kinds of things, absolutely. But on whether or not you should take discrimination against an identified group out of the Indian Act, consultation won't get you anywhere. You can't do it. You cannot consult and get somebody's agreement and then continue to discriminate. And then continue to discriminate while you're consulting.
Thank you, Ms. McIver. The next question is from Catherine McLeod, please.
Thank you, Chair. And thank you to the witnesses, and certainly very compelling testimony. It's interesting, we're doing what they call a pre-study, and I've been here since 2008, and typically we get bills that are well through their process. So a pre-study is a really kind of interesting way to have a discussion, and I'm also looking at what's happening in the Senate right now. And, to be quite frank, I think everyone here had some very compelling points. I mean, I think, Mr. Matson, you indicated very clearly discrimination is still there, as did Ms. McIver, and then the bigger picture in terms of where we go. But, we've come back in 85, we've come back in case after case. I think we need to spend phase 2 looking at that big picture that you're talking about. And phase 1, which we're doing right now, S3, is, clearly, let's get the discrimination out of there so it's fixed, so that we're not back here, we're not spending a lot more money in courts, we're not sort of repeating this process that we've always done. So, you know, having said that, I mean, I think with what's happened in the Senate and with what's happened here, you know, I do want to table my motion right now, which really is saying, you know, the minister should ask for a bit of an extension, get this one right, and I'll just actually sort of read it again. That in light of the recent testimony the committee has heard during its study of the subject matter of Bill S3, an act to amend the Indian Act, elimination of known sex-based inequities in registration, the committee, one, suspend its study in recognition of the bill's technical flaws and inadequate First Nations consultation, resume its study once the government of Canada has consulted with involved parties and ensured there is no technical flaws, and recommend that the Government of Canada request an extension on passing legislation from the Superior Court of Quebec as recommended by Assembly of First Nations Chief Perry Bellegarde, and that the committee report this recommendation to the House. And I don't want to spend I mean, we obviously can debate this, but, you know, I think for me, the testimony is clear. We got to spend a bit of time fixing this. Phase 2 needs to be really focused on that big picture issues, solving the big picture issues, and let's get discrimination out and let's take our time to do it right. So with that,
so just for the benefit of the witnesses, what happens when a member puts a motion forward? We sort of push a pause on the question and answers with the witnesses until we deal with the motion that's now alive on the floor. So I'm looking for any who? Gary, did you want the floor?
Yes, I think given that we've had a number of interruptions and the need for them to conclude, our guests to conclude their testimony, I'm going to respectfully ask that the motion be deferred.
Are you making?
I'm making a motion to defer the motion.
Okay. So we have a motion of deferral, and your light's on, Kathy. Did you want the floor? No. Okay. Well, I'm just going to ask for a show of hands in on the motion of deferral. Show of hands for against the deferral. Against the motion, rather. So that was 4. 5 to 4. The motion fails. Okay, thank you. We'll proceed with the. You still have time.
Yeah, thank you.
Yep.
So perhaps you heard what I believe is the right path forward, and the right path forward being, let's pause, let's get rid of all the discrimination so that we're not back in court the minute this one passes. And then really relieves the government from, instead of having to deal with success, I mean, it's crazy. It's a crazy system that they then look at the big picture and then really focus a nation-to-nation consultation with the big picture. What do you think of that particular path forward?
I get a chance to answer the last question, which was basically along that, you know, what do you think could be the suggestion for type 2 moving forward? And I think you're right. I think you do need to address the discrimination because, like I said, it affects all the First Nations across the country. But then in phase 2, do the nation-to-nation and maybe find a way for Kahnawake and the Mohawks to opt out of registration in the Indian Act and let it be a bottom-up approach and say, these are the people we recognize as Mohawks of Kahnawake, now register them. If people don't fall under our criteria, then they're not eligible to be recognized as Mohawks. By all means, if they want to go to other communities and they want to be registered under their community, we could find a way to I guess, accommodate all of the communities. But Kahnawake, because we have such a different take, and we have since time immemorial with regard to, you know, it being imposed of who could belong and who could come and live in our community and who could be a part of us, we felt we had to put in provisions that protect that. Because these things that are in our culture, and the Turo, and the Dayugjuguan Huxta, and everything that makes us Ganyagahaga might be different from what makes someone Squamish, might be different from what makes someone Abenaki, and so forth and so forth. So that's where the nation-to-nation needs to happen in phase 2.
we'll have to leave it there. I just want to clarify, I misspoke after our vote. The motion did not fail. In fact, the motion of deferral passed. So the motion is still, we still have a motion to deal with it another time. So I just wanted to be clear about that. The next question is Michael McLeod, please.
Thank you, Mr. Chair, and thank you for the presentations. Very interesting discussion, and I see a number of arguments and a number of positions being put forward that I hear in my own riding of Northwest Territories. There's many of our Aboriginal governments, and we have 6, that are very clear that nobody speaks for them. And they don't fall under any national organization. They speak for themselves, they represent themselves. And of course, that causes challenges sometimes because governments want to talk to AFN or National Métis, and none of my organizations except the Inuvialuit fall under one of the national bodies. And I'm trying to follow what everybody's saying, and I recognize, and we've heard it before, that being recognized as a status Indian does not automatically make you part of the community or a citizen of a nation. So I'm trying to follow on some of the other pieces of legislation that came before me, and I want to ask the question to Kasinawa, Skydeer, and Chief Norton about how you handled BC 31 and recognizing there was a number of people that got status then. And were they accepted, or were they not accepted because they didn't meet your membership code?
Mm-hmm. Well, after C31 gave back the women their rights, there was a ceremony that took place where we welcomed the women back. And then the children, who are, if you want to say, a product of mixed marriage, they have to meet a criteria, 4 out of 8 great grandparents. We tried to move away from blood quantum. We feel that blood quantum is a foreign government, being the US's way of identifying who are Indians under their laws for border crossing and whatnot. So that's the criteria, and there are people who fall outside of that. There are people who are living in our community right now who don't fit that criteria, so hence now we're trying to develop residency law. Who could live in the community and who has rights and entitlement? And I know that Canada's obligation is to protect acquired rights. As she had mentioned before, all of those non-Native women who married in, some of them are still living in our community. And, you know, that poses a problem for us, but we said prior to that 81 date, you know, when we set and tried to rectify and say anybody from this point who marries non-Indigenous will have to leave the community, but the children can come back, granted they meet the criteria, and granted they marry back in. You know, it's very strict, I know that, and that's why he said if people want to call us racist, discriminatory, say what you will, but we have responsibilities to ensure certain things continue for the next 7 generations, that our identities will be strong in the future. So there's going to be court challenges. It's going to keep happening. There's going to be human rights complaints. But you know what? At the end of the day, we'll cross those bridges when they come. And ultimately, it's up to the community.
Yeah. Mr. Chairman, we're in a little bit of a different situation because we don't have reserves in Northwest Territories. But we have
just 1 minute left, Mike.
Aboriginal communities, and we use what they call a community acceptance vote. So a person wants to qualify to become part of the band council or the land claim group, then they do a vote. So I just want to be clear, are you suggesting, I couldn't quite follow what you said. You said go ahead with phase 1 and consult with phase 2, or you don't care either way what happens?
I think we made compelling arguments about being mindful about how opening up registration has impact on each individual community, you know, but at the same time, we're aware that, like you said, this law is going to affect every...
But our decision is to go ahead or stop or slow down. What are you telling us?
I'm afraid we're out of time there, Michael. We're over time, in fact, on that one.
Sorry, thanks.
But no problem. We are now at our final question, and it's a 3-minute question, and it comes from Romeo Saganash, please.
Oh, great. Thank you.
Yeah.
I've also mentioned this, Mr. Chair, at the outset, that I feel that to this was unfortunately a missed opportunity for the government. They could have started earlier on this issue. They haven't unfortunately, so we're caught with this deadline from the Superior Court of Quebec. I want to read a quote that I found this morning. And it says, the First Nations across this country are distinct, just as they are similar in certain circumstances. It needs to be at the initiation of First Nations communities, and the First Nations communities need to see the benefit in initiating, expanding on, and harnessing that discussion. If it's not driven by the First Nations communities, it simply will not work. That's a quote from the testimony of our current Minister of Justice from 2010. And I think that's the point that we want to make here with the motion that's being proposed, that we do it right. And I was going to ask the question to Ms. McIver, because she did say similar things in 2010. So I'm going to ask the questions to the three that are remaining here. Where should we go really from here on? Because I hear your positions pretty clear, pretty simple and straightforward. And I would like to know your position on where do we go from here?
Well, first thing first, fix all the gender discrimination stemming from the Indian Act and inequalities going forward after April 17th, 1985 that I recommend, and going back to the beginning. And I think that's a testimony that you've heard. But I think a thorough analysis of Section 6 of the Indian Act, A, B, C, D, E, F, and then 2 and 3, for the Government of Canada to undo colonization, fix all the discrimination in that, provide a list of all those individuals, and then let the communities take their membership or citizenship, how they decide their structure of their communities, which some are in place already, as I've heard from the colleagues over here, and allow for them then to approach the Government of Canada saying, this person was born in our community, they meet our criteria, give them status, or or I don't know if status might be a separate thing, or it might go away, but I think it should come back to the communities, saying we have a nation-born infant, and they're part of our community after a thorough analysis of Section 6 of the Indian Act.
I'm afraid that's the 3 minutes there, Romeo. So we've come to the end of the panel. I want to say to you, Chief Kasanhawa and Chief Joseph and Ms. McIver, now absent, and Mr. Matson, thank you very much for being with us here today, for making the trip and sharing your very well-considered testimony. It's very useful indeed to us and will be taken very seriously. Thank you for your time, and I'll look for a motion to adjourn. Do you want the floor, Gary?
I just want to take a moment to thank Michelle for being an incredible resource for us. I know she'll be taking some time, so I do. I think I can say on behalf of the members here to thank her for her incredible support and service.
Small envelope with a little gift as well.
That's so nice of you.
Thank you very much. We're adjourned.